Hello, dear students. I hope you are all doing well. The wait is over. The practice batch is here. It's time to gear up and focus on honing your skills. In this batch, you will get dictations from SSC's previous years, including 2024, 23, 22, and beyond. Each video will feature dictation from one shift. Your responsibility is to practice each of these dictations diligently to achieve excellence. Let us now begin the session. Listen carefully and write with full concentration. All the best. Get ready. Start.
The question, therefore, that has to be answered in this petition is as to whether there was any valid payment after the award or deposit in accordance with the provisions of Section 31 of the Land Acquisition Act 1894, and secondly, whether the said payment did amount to a valid tender of the amount of compensation to the tenure holders or not. It has also to be seen as to whether this payment after 31 years would amount to a payment that would not attract the provisions of Section 24 within bracket 2 of the 2013 Act. In order to attract the provisions of Section 24 within bracket 2 of the 2013 Act, the fiction provided for therein of a deemed lapse has to be pressed into service, for which the necessary ingredient would be the existence of a fact which has to be contemplated in order to apply the fiction. Thus, the fact should be presumed to be in existence as on the date of the enforcement of the 2013 Act, in order to invoke the fictional clause as contained in section 24 within bracket 2 of the 2013 Act. The question is as to whether what should be the date of payment of compensation in order to attract the aforesaid fiction. It is here that we find that the provisions of section 24 within bracket 2 of the 2013 Act require three conditions to be fulfilled, namely that the award should have been made 5 years or more prior to the enforcement of the Act. The aforesaid condition is fulfilled in the present case, and the procession was also taken. The payment has been made in 2011. On a plain reading of the aforesaid provisions, the fact of payment of compensation did exist as prior to 1st of January 2014. Thus, the existence of the said fact eliminates the possibility of invoking the fictional clause as contained in section 24 within bracket 2 of the 2013 Act, as the payment had been tendered prior to 1/1/2024. Consequently, if the payment of compensation has been made prior to 1/1/2014, the same cannot be said to be an invalid payment unless the payment which has been made falls short of the requisite payment to which the tenure holder was entitled. In our considered opinion, if the payment which has been tendered to the petitioners by way of checks, which is a literal payment as against the amount calculated under the award, is short of the amount which ought to have been paid to the petitioners under the award, then in that event the said payment cannot be said to be the full and complete payment as contemplated under the award. If that be the situation, then the petitioners can claim the benefit of section 24 within bracket 2 of the 2013 Act, provided there is an evidence to the effect that the payment made to the petitioners falls short of the payment to which the petitioners were entitled under the award. In this view of the matter, the levy period of 5 years, as was urged on behalf of the petitioners, would not come to the advantage of the petitioners, because the said period of 5 years is to be calculated only for the purpose of computing the period of the date of award 5 years prior to 1/1/2014. The said leeway period is not in relation to or is contemplated to apply for possession and payment of compensation that can be prior to 1/1/2014. If the payment or the possession has not taken place on or before 1/1/2014, then the provisions of section 24 within bracket 2 will be clearly attracted, provided the award had been made 5 years prior to 1/1/2014. Consequently, the decision of the apex court in the case of Delhi Development Authority versus Reena Suri Supra clearly puts a final seal on the matter as per the ratio of paragraph 3 of the aforesaid decision, which applies on the facts of the present case as it stands today. It appears that during the investigation, the appellants were arrested, and it is alleged that from their possession some stolen articles recovered. It then appears then test identification parade held in the premises of District Jail Bahraich, where appellants were identified by the witnesses including PW1, 2, 3, and 4. It further appears that stolen articles recovered from the possession of appellants were also put on test identification parade, and the same were identified by the witnesses. The police, after completing the investigation, submitted a charge sheet against all the appellants under sections 396 and 412 of the Indian Penal Code. On the basis of aforesaid charge sheet, learned magistrate took cognizance of the offence and later on committed the case to the Court of Sessions as the offence under Article 396 and 412 of the IPC are exclusively triable by the Court of Sessions. Thereafter, the charges framed against the appellants under sections 396 and 412 of the IPC and the same were explained to them, to which they pleaded not guilty and claimed to be tried. Thereafter, the prosecution examined altogether 7 witnesses, out of whom PW1 and PW2 are witnesses of facts, and they claimed that they identified the appellants during the test identification parade held in jail premises, as they were the persons concerned who committed dacoity. PW5 is the executive magistrate in whose supervision test identification parade held in the district jail. Bahraich PW6 is the investigating officer, whereas PW7 is the police constable who took the appellants to the Bahraich jail after their remand. The prosecution also brought on the record various documentary evidence. It appears that after considering the arguments and evidences on the record, the learned court concluded that the appellants had committed dacoity in the house of informant and other villagers in which one person has died. Therefore, appellants committed the offence under Section 396 of the IPC, thus convicted the appellants for the said offence. However, since the appellants have been convicted under Section 396 of the IPC, therefore, learned court below not convicted them under Section 412 of the IPC. The learned trial court sentenced all the appellants to undergo imprisonment for life against the aforesaid judgment of conviction and order of sentence present appeal filed. While assailing the impugned judgment, learned counsels appearing for the appellants had submitted that admittedly the appellants were arrested on 4/1/1979 and they have been put on test identification parade on 23/1979, that is after more than 2.5 months. Stop.
So, how was the dictation? I hope you managed it. Write it well. Don't forget to share your scores in the comments. I do love to know how you did. By the way, the dictation was clear, right? Let me know if you faced any issues. Keep practicing regularly, and I am sure you will do great in your exams. Good luck and keep up the hard work.